number.
Okay, I'm trying to get my notes here.
Equipment.
Oh, yeah, right. Right. Yes, we have a whole host of equipment, and since we're contracting out, it's not being utilized. What are we doing with that equipment?
Well,
I haven't seen Deputy Supervisor pull over his emails. I know exactly what we're doing.
I'll say.
Why don't you take that one?
And,
Sure.
And obviously, Mr. Survey and the public, it's not something that you would be aware of, but there's a lot of work that's gone into this in the background. Obviously, that equipment, the defining moment that we weren't going to be using that in-house ultimately came with the budget, the 2013 budget. And it was from that point forward that we started to identify what we were going to do. There are items, serviceable equipment, that we are going to maintain in our care. It's going to be serviceable. That means it will be running if we need to use it. The remainder of the equipment, and the equipment is surplus items, not only hand tools and lawnmowers, things of that nature, but also vehicles as well. I've worked, and I'll let...
But I thought we were going to sell some of the stuff.
Yeah, let me finish.
Okay.
So I've been working very closely with Bishop and Mr. Thomas and Mr. Arcaro, and we've identified, and also I should mention George Hogman.
Right.
And they've identified the items that they feel operationally that we should maintain, and then we're going to have a final list of surplus equipment that we're going to make available for purchase directly from the town of Rye. As is, we'll make arrangements to have anyone who's interested in the items to come and see it. You want it, pay us, it's yours, and we're going to move on. So, Mr. Serby, you're 2 for 2 tonight with me. So, exactly right. The items that are surplus are going to be sold, and over the next month or so, we're going to identify the process and identified a master list. But go ahead, Bishop, finish that.
Okay. And in terms of the snow...
Hold on, just on that last point, though.
On this?
So, it's a very good question, actually. And the full intent is to sell what makes sense and what doesn't make sense to sell. Can you put the list on the website as soon as we finalize it?
As soon as we finalize it, absolutely. Yeah.
So I'll put the list of what we decided to maintain, because we're trying to be 1,000% transparent, what we're intending to maintain, what we're intending to sell, and obviously we're looking to promote what we're looking to sell as soon as possible.
Absolutely.
Good, thank you. And the last, yes, the snow issue.
The snow issue, I think, relates to that very large snowfall that we had. It was substantial in nature. Mr. Servy's absolutely right. It took them 2 days to finish up the parking lot. It also took them, they got this sidewalk done the second day at Rytown Park. There was a lot of work there, and there was a lot of work for a lot of people in a lot of places. So our focus was to make sure that 10 Pearl Street was done and make sure that Crawford Park was operational, because we have functions at Crawford Park. Rytown Park has always been, and I hesitate to say it, but they were third in the priority list, because in the wintertime, Rytown Park is a passive park. And we don't necessarily have any activities there other than people that want to go there. So we do Rytown Park last, and that's okay. Basically what happened in that particular situation.
All right, and then as long as you're up there, let's stay up there. Let's go right to Resolution E, which is relevant to this, right?
I need to get my stuff.
So. Thank you, Mr. Servey, for your questions. But in terms of any other questions from the public? So Resolution E, let's go straight to Resolution E, because it's relevant to precisely the questions that Mr. Survey was asking. So you want to take us through where we are? So we got 2 bids and 1 was withdrawn.
Right. Just to make sure that...
Yeah, we can go through it. We're also trying to get to executive session. So we got 2 bids, 1 was withdrawn. And so, what are you proposing?
And a third bidder came in late, etc.
So we
were concerned.
Just to be clear, this is for replacing the $1,000 a week handyman contract, right?
It's called On-Call Property Services.
Right. On-Call Property Services.
We came up with a list of tasks that was included as part of the RFP.
Right.
And we were a bit surprised that, we didn't get a lot of bidders.
Yep.
All right. At most, we got 3. 1, as Supervisor mentioned already, came in late. and one of the on-time bidders withdrew their bid, then later on said that they didn't want to withdraw their bid, so...
Oh, he came back again?
Oh, yeah, he called again. He had second thoughts and said, no, maybe I'll leave my bid in.
So, just to cut to the chase.
In the interim, one of the things that we looked at was the prices did seem substantially high to us based on the hourly rates that we were given. We started to do a little bit more research on it, and we are now almost experts in the prevailing wage clause.
Okay.
And it turns out that the bidders are primarily bidding on what they call Article 8 prevailing wages. There are two schedules. There's Article 8 and Article 9. Article 8 prevailing wages are mostly construction-type wages. They're there for the large projects, be it bridges, be it roads, be it buildings, and they cover a lot of the disciplines, be it steel workers, welders, etc. Okay. Those rates are substantially high. There is a second section which is called Article 9 wages, which is much more along the lines of landscapers and less skilled labor.
Got it.
The kind of work that we're talking about here is minor handyman type work,
Right.
which we think falls
Do you
into...
think they erroneously bid on Article 8 wages rather than Article 9?
No, they weren't really erroneous. We actually went through the list with the Department of Labor.
Oh,
and what we want to propose to the commissioners to the board is basically we want you to, in effect, reject all the bids that were received,
Right.
give us the time to rewrite the scope of work so that we segregate Article 9 work
Right.
and then have a separate, perhaps, RFP for the Article 8 work.
Okay.
What will happen is that, I think, will produce, A, much higher
For
response rates.
tonight's purposes, we're rejecting the bids?
Well, that's what we're asking you to do.
And then you're going to come back with a new RFP?
Right.
All right.
Now,
So
if you
I-
notice, if you notice the resolution, what we need to do, since our emergency resolution expires on May 31st,
Right.
we need to ask for an extension. We're asking for an extension to August 31st, which will then make us, how can I call it, concurrent with the September 1 landscaping agreement.
We're not putting those together, though.
We don't necessarily have to. We
Well,
can,
actually, but
we don't have
What I was
to.
going to suggest, Billy, Councilman DePursuit, for tonight's purposes, we need to reject the bid. And I think what we should do is what you're intimating. I think we need to revisit these RFPs. I think you're absolutely right. I think when we should sit down with Mr. Nowotny, and as he re-puts this together, I want to examine what we're doing, because I got to say, Mr. Surrey's right. We don't want to be paying these guys $1,000 a week for in perpetuity. So what I want to do is I want to examine, I think as you're suggesting, how we're going to RFP this next set of work.
Yeah, and I don't think that we need to wait till August. I think that we can probably move this along because we have the framework in place.
Right, I agree with
And
you,
it's just
Billy.
segregating.
Okay.
And either I'm either going to say it now or I'm going to say it in my comments, but I just want to make one comment about the scheduling of the hourly rate. And the RFP was done very well because it also provided, it also provided for the town of Rye to go into a contract, just like we pre-bid plumbers and electricians, that go right into a contract to know exactly what the prevailing wage was. If we had someone to put a wall, we knew what the prevailing wage was for a mason,
Right.
and it went one step further to understand whether or not that the contractor would provide the materials, and if they did, are they making a profit on the materials, or is it just going to be, that we pay the price of the materials? So it was done very well. There was no question about that. But I think you're right. We just need to make it a little bit more simple. But for the record, I do not agree about putting this resolution in with the grass cutting. I think it has to be two separate resolutions.
All right. That's fine.
RFPs.
Okay.
Yeah, but in terms of what date do you think? July 31 for
I
this
think July
resolution?
31 should be, we should be good to go.
Yeah, I think we can be ready for
Because
that.
we pulled this together relatively quick.
Yeah.
And we have
Yeah.
the framework. I say we should...
All right, so can I get a motion to approve this resolution as amended to read July 31 rather than August 31?
Mm-hmm.
Can I get a motion to approve this
Yes.
resolution?
So moved.
Can I get a second?
Second.
Perfect. All in favor? All in favor?
Whatever you decide.
Is everybody, they're all in favor?
Aye.
Aye. Okay, perfect.
Do we need a resolution to reject the bid?
I would assume so. I'll yield to the
I'll
attorney.
entertain, I will make a motion to reject the bids for the, what's it called?
On-call property services.
I get a second?
Second.
All in favor?
Aye.
Okay, perfect. Okay, thank
Thank
you,
you.
Mr. Survey, again for your questions. Thank you, Mr. Nowotny, for your, great. Okay, Mr. Markowitz. Good evening.
The first resolution, Resolution A, is to settle an existing certiorari for the Evelyn Corp apartment complex, which is a 71-unit cooperative building located on Tompkins Avenue in Mamaroneck. As you can see from the resolution, it spans a period of 7 years from 2006 through 2012. It involves reductions for 4 of the 7 years, specifically the first 4 years, and no reductions in value for the last 3 years. This has been a long discussion period on this property. Initially, the opposition provided appraisals indicating significantly more reductions. What I'm going to do is read what the assessment was, what it was reduced to, and then talk a little bit about what their appraised value was.
Actually, hold on. Do you have any questions, or are we ready to approve this?
I have no questions. This has been going on for a
Yeah,
long
exactly.
This has been going on for a
So
long
unless anybody
time.
has any questions or comments, I'm happy to, I know we've been talking about this before.
We've discussed this many times. It's been a long-standing issue.
So can I get a motion to approve the certiorari with Evelyn Court Apartments Corporation?
So moved.
Second?
Second.
All in favor?
Aye.
Okay, Mr. Marcos, I'm making your life easy here.
Thank you. I appreciate
That's which
that.
unusual, as you know, we've been talking about this one forever.
Yes.
Is this you changing the date of the June meeting?
Well, it is you changing the date of the joint
I want to
meeting.
change the locale of the June meeting. I want to change the locale. Why don't we, let's go to
Not the
Rhinebeck.
date. I checked with them already, and the date is available for
Oh,
both
good.
of them.
So let's go to that. Not change the date.
Park
The date
Commission
thing
and-
on
Change the location.
Stay the date on the 18th and change the locale to Rhinebeck. And Mr. Nowotny, oh, is he gone?
No, you'll be right back.
All right. Mr. Arcaro, do you remember to remind the Rhineton Park people that will be in Rhinebeck for June 18th?
It's going to be in the school like we always have it over
I
there.
presume, yep.
Yes.
Oh, great.
Orange.
Thank you, Town Clerk Vespi. Right there, boom, right with the answer. That's what I like to see.
Will you be moving the Rye Town Park Commission meeting
Yes.
there
Yes.
as well?
Yeah.
So we can stay, we'll be
Yeah.
staying at 8 p.m.?
Yep. Okay, great. Can I get a motion to approve the locale change of the June 18th meeting to Rhinebeck's, what is it, the...
High school.
What's the name of the high school, Rhinebeck High
High
School?
school, yeah.
So moved.
Second? Okay, all in favor?
Aye.
Now let's rock and roll here. Award the bid for southeast wall of Otter Creek.
No, I need to do a public hearing first.
Was that
C.
before or after? Oh,
C.
do I take out C? Oh, why would, okay,
Local law filing.
okay.
I'd like to make a motion that we hold a public...
Well, hold on, I want to actually discuss this one for 2 seconds. Sorry, you know, this is my favorite topic.
I know it is.
Well,
I haven't
do it.
Mr. Markowitz off the hook
I can
here.
do it in almost 2 seconds, if I may.
Yeah,
As the board is aware, we have actually an INE law, and we adopted it shortly after we took office in 2009. However, the penalties in that law were not, in our opinion, sufficient. We had, I don't know, about 30%
This year,
cooperation.
just 27%.
The law had zero impact. The law had zero
Right,
impact.
well, so
No
what we've
impact
done is
whatsoever.
this. We have modeled this after the New York City law, which actually provides for what I'm going to call enhanced penalties, which means if
Enhanced, there were no penalties in the last one.
well, there were. They just weren't very...
What were the penalties?
They were similar to this, but let me just go on. Okay.
What?
There's a penalty that for the first year, if you fail to file, you can be penalized up to 3% of the assessed value for the fee for the year. However, if it continues into the next year, it's 4%, and after that, it would go up to 5%. So what we've done is we've provided an escalating scale of penalties to be imposed by the assessor for failure to comply. What we'd wanted to do, as you know, in the past, was to make failure to comply an automatic dismissal of your cert case, which you cannot do. So this is the next best thing. It is modeled after New York City, which has a pretty successful program. And so we think that this is a step up from what we had, an improvement to our prior law. And in order to adopt it, we have to hold a public hearing, which we would do on June 18th. So all you need to do tonight is schedule the public hearing
I
on June 18th.
just understand a couple of things.
Yeah.
And explain what I know, and then you can help further understand. I want to thank Assemblyman Steve Otis for his help. We had a conference call with Mr. Markowitz, Mr. Dono, myself, Assemblyman Otis, and Assemblywoman Galiff, and to talk about the laws that we've been trying to get approved for the last 3 years now.
That's correct.
Assemblyman Otis came back to us and said that for this I&E statement, we don't need a new law. He said you can apply penalties on your own under your own town law and follow the same thing that New York State did. So this is
New York City.
New York City, I apologize, New York City. This is a sea change. This is a
Game changer.
game changer. Thank you, Mr. Mark. It's a game changer for us. So now the board's going to have to get ready to take some heat. And, we have to think about what this is going to do. But as everybody knows, us asking for I&E, had no impact. They gave us nothing. It did not have any change whatsoever. The system is still being gamed, and I won't go into my, monthly speech, but we're still being gamed. So now what we're recommending is if they don't provide the I&E, they're going to pay a fine. So when I say before there was no, now they're going to pay a fine, and that'll get their attention. That'll get their attention real fast. Now, Mr. Town Attorney Noto, if we have a public hearing in June, can we approve it in June?
Yes.
All right, and then when does it become with effect?
It becomes in effect within 30 days or when we file it with the Secretary of State. So it'll be in effect for next year's roll.
Well, next year, but not this year's?
Well, this year's roll is June, right?
This year's roll
it's
is
already
being
done.
released June 1st.
Yeah. Our existing I&E law is applicable for this year. Just this law.
Yeah, but just let me understand. And this is something we need to think about and discuss. First and foremost, are we going to, so we're saying anybody, every one of the 1,200 commercial property owners, or only those?
Income-producing property. Same
is-
definition as before, income-producing property.
Okay, but, sorry, but in our previous law, we only,
No, same.
No, hold on. The previous law, if you didn't file a certiorari, you didn't have to produce anything. Well, let me put it this way. The penalty was supposed to be if you filed a certiorari, we would kick you out, which we found out we couldn't do.
Can't do that.
I understand that. So we had no penalty, no effective penalty,
Okay.
right?
Yeah.
So in other words, if you weren't filing a certiorari, there was no need to file an I&E the way we set up the previous law.
That's
The only time
that is accurate.
Right.
Yeah.
So my question to you is, are we only going to penalize those people that file certioraries?
No. If you don't, you have to file an I&E, period, whether you file a cert or not.
Okay, now
If you do not file an I&E, you are subject to a
I
penalty.
will understand that,
Yeah.
and I think the board and all of us need to think about it and discuss this.
Well, that's why we're going to have a public hearing.
Yeah, but I
please.
just want us
It's a
to...
little form.
I personally think that...
It's a one-page
You want
form.
to take it now, or you just want to discuss this now?
Well, I
We're
have a
gonna
question for the, I have a question for the
It's your
town
call
attorney.
when you want to discuss
Well, I
it.
want to discuss a little bit, I want to hear from Councilman Encino, but can I, go ahead, I want to ask a question before. Can we restrict it to those people that file a certiorari filing?
No, because that's discriminatory.
Why is it discriminatory?
Well, because the whole point of the I&E is so he can do an assessment and get accurate information. It's got nothing to do with a certiorari. Basically, he's saying, I need this information to properly assess your property. So you can't penalize people for filing a cert.
Well, but our law is currently constructed, it could be
No, it
construed the
didn't.
same
It
way.
did not do that. It basically
did.
had no penalty, which was the
No, the
problem.
penalty was, the
No,
way it
we
was
wanted it
designed.
to have that penalty, but we didn't put it in the law because we knew we couldn't do that. We knew in advance we couldn't do that.
But we didn't ever attempt to get I&Es
No, we
from the
won-
community.
Well, we did. Mitchell did. We sent out the information. We asked for the I&E, but we had no punishment except you're being rejected at the bar level. In other words, when you come into the BAR,
Right.
you're automatically declined, which just happens anyway. That's just a
I'm
formality.
in agreement with the supervisor. I thought it was just for people
No,
who are
because you can't. Because first of all, you don't know if they're filing a cert until after this is all over with,
Well,
right? I mean, in other words, first you get your notice,
I remember our discussion.
and then you file your cert. So
I remember our discussion, pretty much just where Supervisor Carver and Councilwoman Mendocino are
Right,
discussing.
exactly.
Our discussions were that if you filed a certiorari here in the town of Rye, and then you came and you said, my property is worth $500,000, and clearly it's worth over $3 million. Mitch Markowitz would turn around and say, okay, you need to produce your I&E.
you do that anyway.
Property.
You do that anyway as discovery.
Right.
That happens anyway in a cert.
And guess what? And they don't have to produce it.
In court, they do. By the time we get to court,
Mr. Noto, you apologize, but you have to try and listen to what we're saying here.
I understand exactly what you're saying.
So what I'd like you to do is some legal research here. And what I need you to tell us, the board, is whether, I disagree with, well, I don't have any legal premise, but I don't know if you've actually studied the law to find out if what we're suggesting is discriminatory.
Well,
Because our previous law, just let me finish the point. Let me
it's
just
a matter
finish,
of
no,
timing.
can I just finish the point?
Okay.
We're all very clear that the previous law was designed only to impact people that are filing certioraries.
No,
Yes, it
that's
was.
not what your law says. The law today...
I'm not asking you what it says.
Oh, well,
I'm
that's-
telling you the policy,
Oh.
no, but, I mean, I wish I had a blackboard here. It was designed to only impact people that were filing the certiorari. And if we could have done what we proposed to do, then it would have had tremendous impact. Unfortunately, we couldn't do what we wanted to do according to law, according to you. Now, I think you're hearing from the board, before we go to how many commercial properties do we have?
Approximately 1,500.
So we got 50, before I ask 1,500 people, then tell them they're going to pay 3% of the value of their property in a fine to me.
It's up to his discretion.
Yeah, well, no. You can't- I'm not-
2%.
The bottom line
Any
is,
percent.
any percent, just because they didn't file an I&E seems fairly draconian to me. And so I'd like you to do some legal research and find out whether you can do it, apply that penalty only to people filing certioraries. Now, the board will have to make a decision whether they want to be more draconian or not, provide Mr. Markowitz with
I
the
just have a
information he's been
question.
asking. Yep.
When do you impose the penalty? Because
Okay, so that's what I'm saying.
the purpose of the
I'll tell you exactly
INE
what
law, though, this is not a punitive law. What New York City has done and what other communities have done is the purpose of the law
Ours is
is
not
not to
punitive either,
penalize.
but ours is not punitive either. You're
saying
taking a
if you
lawyer's
file a
viewpoint
cert-
that I fundamentally disagree with.
Hold on, let me finish. The purpose of the law is to get information.
Right.
Okay. And that's information we want from everybody. And the reason we want that information is to make his job a little easier. So what we're saying is, if you have an income-producing property, and he has to assess it, please provide us with... Now, by the way, what Mitchell would like to do, and what we'd like to do, is have it done electronically. It's a one-page form. This is not a 30-page This is basically a one-page form. But that information is what he needs to assess your property.
From
Everybody.
But you're talking about older homeowners who...
No, I'm talking about income-producing
No.
property.
Right, but
Yeah.
you're not, what's an
No, we
income-producing
exempted
property?
those. No, we
Anything
took-
above three
What is the
family.
definition that we use that we...
Any property that's income producing,
Right.
that contains we excluded any property containing 3 or less
Right.
dwelling units and classified as homestead.
Yeah.
So anybody that's
we've
classified
taken
as
the
homestead.
position we need
No, you're not listening to the
No, I
town
am listening,
supervisor.
but...
No, you're not listening. I understand. Listen, no one
Let me finish my
understands.
point. Okay. So what you're asking is that we have the law that says you only have to give us this information if you file a cert. And if you don't give us this information after you file a cert, you get penalized.
So that's the current law.
No, that's not the current law. The current law, everybody has to give us an INE law. They just ignore it, is what we're trying to say. There's no penalty for ignoring it. But everybody has to provide the INE. We've not exempted anybody except the same
So the only
same
penalty
definition.
is if you don't file a cert, right?
Yeah. So what I'm saying is, you don't know in advance who's going to file a cert,
Right.
obviously. So
So it can't be discriminatory.
it is, but what we're saying is, if you have to file, according to this, by April 1st, you're supposed to give us the information. So between April and June, he takes that information and plugs it into his formula to do the assessment. Okay? And you're saying if you didn't give it to us on April 1st, and in June your assessment goes up and you file a cert, we're then going to fine you for not providing the INE. That's
I almost
Yes.
see it as two separate
And
things.
actually,
right. I'm not.
So-
I don't know how you do a law like that.
I see it as two separate
that's what I'm
things.
saying.
One is people coming into compliance with the INE across the board, and one is just having to help us have that information for those in anticipation that will possibly
Yeah, that's
file a
exact-
cert,
that's
so that our
exactly-
files are all up to date across
Right.
the board. I don't necessarily see them as needing to be related. One is just
No, you're absolutely right.
gathering
Look,
the correct
The question,
information.
the fundamental question is, for this board, is do you want to impact 1,500 commercial property owners, or do you want to impact 250 commercial
Well,
property
how are
owners?
we impacting with them if we're just asking them to comply with a law that already exists?
Well, okay.
They just
so-
want information.
So I don't think you were here at the time, Councilman Collins. We designed a law
Right.
to impact 250 people, not commercial property. That's the way we designed it. We designed it that way. That was the way we pitched it. I went to the Chamber of Commerce. I talked to them.
Right.
I said, if you're not filing certiorari, forget about it. You don't need it. That's the recollection of the board. That's exactly the way we pitched it.
Right.
So that's why I'm talking about today.
Why don't you want to gather that information
You can,
regardless?
but you know, that's what I'm saying. You make the decision. And the decision is how much, when you go to...
Well, my goal is to always get the assessment as accurate as possible.
Well,
so
that's
this
fine.
information
But the
will help
question
us.
is, how hard are you prepared to come down on 1,500 commercial property owners? If you think the information is that...
Why is it considered coming down hard on them if we're just asking them to supply
Yeah,
information?
I mean, I'm not
that
sure
they're
why-
required
I'm not
to
sure
provide?
Yes, they've never done it before. They don't want to give you the information. They're afraid that the IRS... You know, you go talk
No,
to
I
10 commercial
understand
property
that.
owners.
Nobody wants to.
Nobody
have that
wants
information.
more
I'm saying if it's the law,
owners.
it's the law, and some people do it,
So the
some people
trade-off
don't.
is, so let's just define for everybody, you're absolutely correct. Mr. Markowitz, given his druthers, would have 1,500 INE statements.
Right, exactly.
It would make the valuations more accurate.
It's like the homeowners are required
Can I
to
finish?
fill out the paperwork, though.
Well,
You know, I have to put
you
in
don't have to fill out any
that
paperwork.
when we do stuff, you
No, you don't have
ask.
to fill any paperwork.
Well, if you want the star exemption, you
There's
can.
exemptions
True,
you do.
there's paperwork you fill out, or I got things in the mail last year that asked me to confirm my square footage, and if I saw anything not accurate.
You don't get fined if you don't do it.
No, but
That's what we're talking about here. We're talking about a 3% fine on the value of your property.
Well, I think we're
That's,
going to have a public hearing.
so if you pay $30,000 in taxes, you're going to pay a $30,000 fine. If you pay $50,000 in taxes, you're going to pay a $50,000 fine. Are you prepared to apply a $50,000?
Wait a second, I'm not sure about that math.
Sure. Mr.
never
Markets,
decided it.
I will
That's
tell
what the information
you,
gathering
listen,
line.
Mr. Markets will explain to you that the average commercial property owner pays 3% of the value of the property in taxes, correct?
Correct.
So if you're charging a 3% the 3% of the assessed value. So if he's paying $50,000 in taxes, he's going to pay a $50,000 fine because he didn't give you an INE statement. Now, look, if that's what the board wants to do, that's fine, but at a minimum, we ought to discuss this.
Right.
Now, what I'm
I'm certainly
suggesting,
not prepared to
and what
make
I want to, we're not going to, exactly, that's why we're having the conversation
Yeah.
tonight. And what I want to, if you could do the legal work on this, if we have the option of only applying the penalty to the fine to those people who filed certiorari, because then we need the information. Now I'm in an at-need situation.
I feel like we need that this is where I'm hung up, and this is where we can have another conversation offline that can become more educated
Sure.
on the process. If we want the most accurate assessments on both residential and commercial properties in all our villages, don't we need this information regardless to help get us towards accurate assessments?
Yes, it's very helpful.
Okay, that's my yes and no thing, and then we can move on to
You can make the fine lower. You
educating
can
me
make it 1%,
more about it,
Joe.
so I can
Yes, the
have
only
a
question is,
better-
are we prepared, is that information sufficiently important that you're prepared to charge a $50,000 fine?
And that's what,
Right.
we have to discuss,
So if they
obviously.
file a certiorari,
All right,
at
so
what
let's
point
schedule the
do we
Sorry.
demand to get an income statement?
Okay.
Let's make a motion now.
Hold on.
Wait,
Just-
I'm
sorry,
asking,
I didn't-
Councilman Iris had a question. He said, at what point do you get this information after a cert is filed? So after a cert is filed, it goes into the court system, and then there's what we call discovery, which means
Right.
both sides...
No, sorry. You're completely misrepresenting the
I'm
process.
answering his
No,
question.
but you're wrong. I'm sorry.
How am
but
I wrong?
I will tell you how you're wrong.
Okay.
And that's why, because where we come out on this is I would like to apply it this year. I don't want to wait till next year. And if we only go after certiorari, I want it this year. So let me explain the process.
You can't adopt the law before June 18th.
I understand that, so...
Yes, we can.
No,
It's a
anyway.
public hearing.
You can push the calendar.
Oh, okay.
Hold on a second. Joe, if you want to,
Is that right?
you can make a request to Hope tomorrow. Hope can publicize a special meeting for the town. That specific town meeting, we can have a hearing, and we can adopt this law, and we can have it done by next week.
Beautiful. So let me just...
What is it you want the law to do now?
First of all,
lost there.
exactly.
Answering your
So
question.
let me answer Mr. Norris's question differently than you have.
Okay.
You're coming out with a roll in June, correct?
Yes.
Okay. And then when do people have to have their certiorari, was it grievance, or is it commercial property called a grievance, or
If they
certiorari
believe
challenge?
that their assessment is incorrect, they have between June 1st and the third Tuesday in June to file a
All right,
grievance
what
with the
it-
Board of Assessment Review. I believe
what
it's
is
the
that?
18th.
June 18th, the same
Yeah,
night as our
yeah.
meeting.
Same, that's why we're moving it.
So they have from June 1st to June 18th, if you're a commercial property owner, to file a grievance with the Board of Assessment Review.
Or if you're a residential property owner.
Yeah, I know, we'll just talk commercial right now. So it's called a grievance when they do it?
Yes,
Okay, so a grievance is prepared for the Board of Assessment Review.
correct.
The Board of Assessment Review has how long to review that?
Has between, I'll call it the end of June or the beginning of July until early September,
Okay. And then you finalize your roll when?
September 15th.
So you have a final roll September 15th. All right. Now, you're talking about discovery and all that. That's confusing the situation. There's no discovery between June and September 15th.
Yeah,
There's
but
no discovery.
There's no cert either.
Okay. So then what I want...
His question was, after a cert's
Okay.
filed, what happens?
So, okay,
That's-
then I muted, sorry, I apologize. When a commercial grievance is filed, if a commercial grievance is not accompanied by an I&E statement,
They're denied a hearing. That's what the law
but we
says.
can't do that.
You can do that. It just says, it's in the law that's in front of you.
Oh, borrow, yeah. No,
Board of
they're going to get it.
Assessment
No,
Review shall deny
I want
hearing.
to apply the 3% fine. I want to catch their attention. I want to apply the New York City fine.
Let me get this
Yeah.
straight. You want to, after the grievance date, which is June, like third
Yeah.
Thursday in June,
Right.
you're saying if they have filed
A grievance,
a grievance
and they have no I&E statement,
and they have no, all right, so you're saying in here,
yeah.
if filed a grievance and no I&E, then the fines kick in.
Yes,
If filed a grievance, okay.
that's what I want to do.
So you want to have a hearing and discuss the two options? And
We
then we'll decide what you want to do?
We can discuss the
Because
two
I'm just
options, yeah,
saying,
sure.
just so you know, New York City's law applies across the board to everybody. You got to give us the information because we need it. And
Yeah, let's just discuss the two options.
So I think you should-
3%?
there's an article in the Post about circulating
Yes.
that and it had remarkable compliance, obviously.
3% of the tax bill.
3% of assessments, but let's be clear here.
That's awfully...
New York City assesses at 45% of market value.
All right, so there's still a lot of money.
1.5%.
There was an article last month or 2 months ago that New York City imposed penalties totaling $27 million.
Here's our money, guys.
We have
Right.
the...
And I can provide...
And they have an 89% compliance rate. So, it's
Right.
now you can lower the fine. Again, you have that discretion if you want to change. If you think that 3% is too high because we're at full value, you can leave it at 1%, not have the sliding scale. But they've had a remarkable amount of compliance, obviously, because of the penalty. So it works. Well, but Joe, either you want the information or you don't. I mean, we can't complain about not having information and then not,
Let's make clear the choice before the board.
Yeah, no, I totally agree.
The choice before the board is to try and get information on all 1,500 properties, and that certainly will enhance. Then the question is, what kind of fines do we apply? And I'm with Councilman Mendocino. There's a lot of, I just don't see the Portchester community supporting that kind of thing. What I do feel that I'm perfectly happy to support is a fine on someone who's filed a certiorari, because they all come in, as we know, you don't want me to go into the thing, $5 million, and they come in and say it's $50,000. And that's an outrage. And so I want that I&E statement. And I'm perfectly happy for a commercial grievance that comes in without an I&E to say, you know what? You just got a 3% fine. Yeah, absolutely. I'm all for that.
I'd like to know how we establish the assessment without the INEs.
The assessor makes his best guess.
Right, and I'm not comfortable with that as our method of accurate assessments.
She didn't say that quite on
No, so you have...
But I want to change the status quo.
As your lawyer, I would not advise you to say that.
When can we, let's go, so we can we...
So have a conversation on the 18th, or let's...
No, I agree. I wanted to go sooner. Do you
All
want
right,
to go
let's
sooner?
do this.
Well, no, even if you adopt it on the 18th, you could still apply it, because you're saying that, you're probably not going to be
Here's what I
applied.
propose.
Because you got to give people notice, Joe, anyway. I don't see how
Deputy
you-
Supervisor Villanova, what's your proposal, Deputy Supervisor?
3 days, correct, Hope?
Oh, no, yeah, not that soon.
Yeah, but I got to do the new law. Oh.
Could
Well,
someone,
we can notify,
notice to the public is 3 days, correct?
Yes.
Okay, Paul, when
Well,
can you have the
I know
law?
about a public
5
hearing.
days.
No, it's a public hearing.
Yeah, it's a public
it's
hearing,
not,
so
it's
it's
not a
5
regular board meeting, it's a
5
public
days?
hearing.
Paul,
yes.
when can you have the,
Sometime next week, I guess. I mean, I got to look at this and see if we can even do it this way, because
All right.
basically you're carving out a category of people that would only really be affected by this, which is people who file a cert. And I'm thinking they're going to come back and say, look, you're basically penalizing people for filing a grievance, which is their constitutional right. So, I mean, we can wait till it gets challenged, of course, but
You're not
let me look at
penalizing
it.
people
Huh?
because they need to provide the INE.
Exactly right.
correct.
But the question is not, if not everybody has to file the INE, only the people that file the grievance.
That's
It's a different category
All
of
right,
people,
well,
right?
I think,
that's my talk.
all right, Paul,
Well, it's true, because if you have a commercial property and you don't file it, and I
Well, do
don't,
the research, do the research.
Discoverable in the
Yeah.
search.
Yeah, do the research.
I'd like to...
everything is discoverable in the cert, yeah.
I'd like to
that's-
schedule
yeah.
a public hearing for this law for the week, what, do June 4th?
Yeah,
Tuesday, June 4th?
yeah.
Does that conflict with court here? Or we can have the public hearing in the
Yeah.
council, chamber.
Yeah, Tuesday, June
No,
4th.
We don't have court.
it's usually a Monday
At
night,
night.
right. Just a-
That's good. So okay, so we can...
I mean, you can have a public hearing on this proposed local law, and then you can amend it at the hearing as well, but then you'd have to
We
probably
could-
renotice it, that's what I'm saying.
No, I'm saying,
You
I like to
adopt it, yeah.
I like to have the modified law noticed, so we can hear that public hearing on June 4th and vote, if we choose to, implement that local law on June 4th.
Yeah, I love it. Beautiful.
What time?
It's okay to do that, Paul?
I think it's awfully, yeah, I mean, there's
Is it 30
let me
days?
check on the public law. I mean, the public notice for local law, no, it's not 30 days, but it's at least
All right,
usually
so-
2 weeks, but
All right, well,
I'll check. I mean,
let's say...
you can reschedule the
Until we
meeting.
hear otherwise.
Oh, so so the resolution will read June 4th or as soon as thereafter that's legally possible. How's that?
That's fine.
Well, yeah, no, you have to set the hearing. I was thinking Joe could call the meeting, but no, you have to, they have to schedule the public hearing with the law.
Thursday the 6th?
And the law has to be on the
Yeah.
website. You have to post it on the website.
Oh, that's right, we're going to have to post it
Yeah,
to public
and
places.
I'm pretty sure you got to give them 10 days. That's my thinking.
All right, so listen,
But-
Hope will let us know tomorrow,
Yeah.
okay?
All right.
Well, don't we have to approve? I'm not going to come back in to just set this up.
Well, you can schedule a public hearing on this proposed local law, which you've already done for June 18th, okay?
No, I'm not. Yeah, I'm not.
No,
I
it's
agree.
okay, then you don't have it. Then I'm saying you schedule another public hearing for another law prior to that, and then you cancel this one, that's all I'm saying.
All right, but the board wants to meet as soon as possible, legally possible, on the public hearing.
Right, so we have to draft the local law, you have to get it in your hands, then you have to schedule the public hearing. That's how it usually works. You want to schedule it without having it in your hands, because we're
Yes.
going to amend this law, obviously. So
Yes.
And so, Mr. Noto,
so
you're
let's
saying-
see, we'll schedule it for June 4th, and then if we can't, we'll let you know, and you'll schedule a special meeting to schedule another meeting.
That's what I'm saying. I don't want to have to schedule a
Well,
special
I
meeting.
don't
Do
know
we have
how
to
long it's going to
discuss
take. You want me to
that
look
bridge when we get
stuff
to it?
up,
Well, I'm wondering,
redraft
is
the
it-
law, make the changes, and you,
Actually, we can be any time of the day, right? What time do you guys want the people?
well, I think you had to do a night for a public hearing for local law, because people are affected by it. I would say have it at 7 o'clock in the morning.
I could
Do we want to go later that week, or you want to stay June 4th?
We could do later that week.
Well, I can't do the 6th, I know that.
You
but-
can't do the 6th? 5th?
We could do the
Why did you do
5th,
June
too.
11th? That gives you plenty of time.
Then have the meeting the following.
June
have a
5th.
public
June
hearing.
5th. If it works, if it doesn't work, just let us know.
Okay.
6 or 7 p.m.
Or June 4th. You want to do June 4th?
or 5.
Oh, just make
All right, sorry, June 4th. June 4th.
Yeah, I don't see how it applies this year anyway, because he just said he wouldn't even have it
What
posted
do you mean?
in
It's
time.
fine this year. I'm going to get it done this year.
You don't have it posted before the 18th.
June 4th, it'll be posted. It's going to happen this year, John. I'm not going to go through another year of the crap.
What time?
June 4th, whatever time people want.
Yeah.
6?
5, 6, 7.
6?
7's fine.
Whatever.
6 is fine.
6 is good. 6 p.m.
Following the state doesn't take a long time, but
No, that's too early, maybe? You know, you have to-
For who?
for the public.
I don't think so.
Oh, are you kidding me?
No.
I'd rather...
The 3
I
people
think
that show
anytime
up will
6
be...
and over.
Let's do it at
That's what I'm saying, 6 o'clock.
7 o'clock.
All right, 7 o'clock.
You're right, Bob, 7 o'clock.
Look, well, the other thing I'm going to do, Mr. Markowitz, if you'd set up a meeting with the Chamber of Commerce beforehand, Mr. Noto, if you could be there as well. I want to meet with the Chamber of Commerce. I want to let them know this is coming. I want them to know there's going to be a public hearing on June 4th at 7 p.m. And I want them to say,
Well,
look,
do you want options, or you just want...
no, I don't want any options. Oh, actually, sorry. I apologize. For June 4th, yes, I guess we should have a couple of options.
Well, I mean, I'm saying you could take this law and reduce the penalties if you want.
No, the options are going to be clear. I think that
I
there's
think
some...
we need to negotiate the penalties. I think those penalties are overly burdensome.
So, yeah, you could lower the penalty to 1% and still have it apply across the board.
Well, let me understand. At the public hearing, you're going to propose something, right?
I'm going to give you a draft local law, and I can
Right.
give you 2 draft local
Yes,
laws.
2
I'm
draft
just
local
saying
laws.
that it's very difficult to have a public hearing on 2 different laws. You know what I'm saying? It's just not really the
Well,
way you do it.
if-
You have a public hearing on a proposed local law, and at the end of
If
that
it's-
hearing, you close the hearing, you adopt the law, you change the law, and then you rehear it. You know what I'm saying?
All right, so
Because
then-
people may show up at the meeting and say,
All right.
look, we like
Well, look,
A, B, and C, we don't like D and E.
So I apologize, I know no one wants to be here till midnight tonight, but I really would really like to see this law approved for this year.
I think it's unlikely it would be applicable this year, because they wouldn't have any notice.
The South Supervisor just said he'd like to have it happen this
I
year.
hear you. And your town attorney is telling you, I think it is unlikely that if they file agreements on June 18th and you adopt the law on June 4th, someone's going to say, gee, I didn't know I'm going to get penalized for filing the cert this year. You didn't tell me. I don't think a court's going to find that unreasonable.
Okay, and then, and ultimately, the process goes to September, correct? Early September, September 15th, when you do the roll, the board finishes its Board of Assessment review.
Board of Assessment Review finishes its deliberations before
So when they
September 15th.
file, they will be notified, and they'll have 30 days to comply. If they haven't complied after 30 days, they will be fined.
That's not what the law says.
I understand that. That's why I'm telling you, we're going to have, and I'm happy, unfortunately, I apologize. We need to, if you're telling me that the law needs to be designed this evening for June 4th, and let's design it. But the law is clear. It's very clear to me that the consensus here is to apply it only to people filing certs.
I don't know. Is that in fact the consensus or not?
That is
It
my
might be the majority. It's probably not the consensus.
Sorry, well, the majority.
So, all right, let me get this clear. You want a local law that requires I&Es only for those people who file a grievance, not a cert. just
Commercial grievance, yep.
Grievance. Is that what I'm hearing?
Yes.
Okay.
I could have sort
To
of...
be applied this year. And they will be notified by the supervisor, the town assessor.
Well, at what time do they file a grievance? Between
June
June
18th.
1st and June 18th?
Yes.
Right.
That's going to be kind of late to do.
I've been trying to say that, but I mean,
Yes,
I think if someone filed a grievance on June 3rd, hypothetically...
We've been for 100 years.
I understand
And I'm
that.
not going to get screwed anymore.
Well, I don't...
So at the end of the day, look, unless the board says it's crazy, but at the end of the day, it's legal, and you're going to give the person a chance to rectify the situation. So on July 1st, June 19th, he will receive every commercial grievance. And there's going to be 250, the same people have been screwing us every year for the last 15 years, are going to file again. And he's going to go back, have you seen the new law? Because the new law says the following. If by, so you're going to get June 9th, if by August 15th,
All right, so...
you have not given me an I&E statement, you will be fined whatever we decide the
So
fine is
what's
going to
the
be.
date then, if following the supervisor's, chronology here. Someone files on June 18th. At what point would you say that you need the I&E for the Board of Assessment Review to make their determination?
I would say as soon as possible as a practical matter. If the Board of Assessment Review receives all the complaints by June 18th, the truth of the matter is it takes till July before everything's inventoried and everybody even knows what all the filings are.
July what, though? It's 2 weeks away, July 1st.